Welcome to Asala's Classroom Talks. Good evening, everyone. This evening, I'm glad that we are going to talk about how to give evidence in a criminal trial. I know all of us are aware that many criminal cases fail, not because witnesses lie to the court, but sometimes it's because the lawyers do not understand courtroom procedures and rules of evidence. And so to guide us in this discussion is none other than our senior counsel, Dr. Mudomi Thiankolu, a distinguished academia as well as a legal practitioner. Dr. Mudomi, we are very pleased to have you on board tonight. And over to you for a few words of introduction.
Thank you very much, Dr. Evelyn. I hope everyone is on board because on my end, it shows only 2 participants.
Yes, it's only you and I, but the audience are elsewhere.
Oh, okay, fair enough.
Mm.
So my name is, has been given, is Mudomi Thiankolu. Dr. Evelyn Asala and I are colleagues at the University of Nairobi Faculty of Law, where we both teach courses that have a lot to do with court practice. For her, she's more into criminal processes. You tend to do a narrower area called evidence law, and in recent times, trial advocacy. And I'm really delighted to be here. Thank you.
Thank you very much, Daktari, for that introduction. Now we get straight into our discussion. And just to open our discussion this evening, Daktari, many people in Kenya fear going to court to give evidence. Yeah. Why is giving evidence in Kenya a risky venture? And is this fear, Daktari, justified?
You have to understand the fear from a historical and sociological point of view. The Kenyan legal system as we know it today has its foundations in colonialism. And unfortunately, the colonial project didn't respect the dignity and rights of Africans. In fact, they called us natives, which was used as a term that suggested we were savages that were not socialized. And because of that historical legacy, the typical Black Kenyans' experience with the legal system historically was not a good experience. And the institutions, unfortunately, have historical legacies that refuse to go even after rounds and rounds of reform and rounds of several generations down the line. So if I may use the cliche language, there is a sense in which the whole experience is alien. You go meet a judge wearing funny clothes, they are speaking in English or in Kiswahili in the typical courtroom, which is in the community at the sub-county level. People speak in their mother tongue. There is all this intimidating presence of security officers, whether they are from the prisons or from the police service or whatever other formation. And basically, there is a way without screaming, yes, shouting very loudly. There are all these signals that don't send very good vibe. And in a country where we have had those histories, recent histories of oppression, abuse of human rights, and other governance challenges, then I wouldn't be surprised that the average citizen called upon to give evidence would have trepidations and might not be an experience they would go through if they had a choice. Thank you.
Thank you very much, Daktari. And just to remind our audience, should you have any question or comment, please feel free to type it in our chat box. And once we are done with this conversation, we shall respond to your questions. Now, Doc, let's dive into the real thing when we talk of evidence.
Yes.
Who is a good witness in court when you want to give evidence? Who is a good witness?
That's a very good question, and why I love it is the word witness. You know, part of the reason cases are lost is that we bring people we say are witnesses, but they never witnessed anything. because you're only deemed to have witnessed, let's say the dispute in court is about an assault. Somebody attacked another one and inflicted serious bodily injury, or it was a motor vehicle accident, or whatever it was. Maybe it was a rape, a defilement. For you to claim to be a witness, there has to be a part of the event in question that you actually saw with your own eyes or heard with your own ears. And the law says if you didn't see it with your own eyes or hear it with your own ears as it unfolded, then you have to have perceived it through any of the other five natural senses of touch, smell, hearing, and whatnot. And the law requires if you're coming to testify about technical matters, perhaps an opinion you hold about an event for expert witnesses, then it has to be an opinion the person holds, the person now giving evidence. So a lot of time people come to court to purport to be witnesses of something they never actually witnessed. Because if you witnessed an accident, what that means is that you saw the collision of the whatever we say that accident was. If you say you are a witness to a fight or to an assault, it means you are at or near the scene of whatever happened, and you could clearly perceive what was happening through any of your five senses. So part of the reason cases are lost, even when we think the cases are straightforward, is we bring people we believe are witnesses and they're not witnesses to anything, which reminds me of a joke I tell the evangelicals. You know, if you attend an evangelical church service, you hear a man or woman coming to give testimony what the Lord has done for them. And you hear a guy saying, I have seen the hand of the Lord. And no one has ever seen, we don't know whether God actually has a hand. I have seen the face of the Lord. And I always tell my students, that's how you know that's a lie, because I am not sure anyone has seen the face of God. So part of the reason cases are lost is we bring people we believe because of our socialization, they were witnesses, when as a matter of technical, legal language, they were not witnesses to the event. Two, cases are lost because even if the guy or lady we actually witnessed it, they are not well prepared by the lawyers or by the party who is calling them to give their story or their testimony now. And I usually tell people, the example I love to give, Evelyn, is there are times I do experiments sometimes with my students. We walk to a building in Nairobi and we go wearing our t-shirts and jeans and whatnot. And even an old man now like me, that kijana wewe ni nani? Unaenda wapi? Uko na appointment na huyo mtu. Very many questions and most likely you won't even be allowed by a mere security guard. Then we go back. We go back. Then go wear our nice suits, groom well, come back to the same building, the same officer, the same protocols about who can access the building, and now they are saluting to us. Karibu mkubwa, karibu mkubwa. It is the same Mudomi and Kolu. It is the same attempt to enter the same building, to see the same guy. This time, no questions asked. There are times I try to access a building deliberately out of research I do with my students. We try to enter a building in a small car. And then again, you ask all these, you have to surmount all these clearances. Then you go borrow a friend's Mercedes or Land Cruiser, and this time now the barriers are being removed without even the guys asking who you are. So the second reason why cases are lost is because we bring witnesses who actually witness the event, but because of how they are packaged, how they are dressed, how they have groomed themselves, the typical, because of again our post-colonial, neo-colonial legacies, the guy is not taken with the seriousness that he should be taken with. The third reason is giving evidence in court is like telling a story. Even in those evangelicals, when they say what the Lord has done for me, they're basically telling you a story, okay?
Yeah.
And we assume everybody is a good storyteller. So
Mm-hmm.
cases are lost not because the witness is lying, not because the witness doesn't know what they're saying. Unfortunately, some of us stammer, some of us don't keep eye contact, some of us don't groom well, some of us have something I call stage fright. You know, you find somebody is suddenly in a serious forum we call a court of law with all the intimidation,
Yeah.
and they are suddenly sweating, they are suddenly twitching their nose, they are suddenly shaking and shivering. All
Mm-hmm.
these things, I usually summarize them at the words I call stage fright. And
Mm-hmm.
because lawyers fail to prepare their witnesses for the natural intimidation of the environment in which they're going to give the evidence, so you find the witness comes there and is completely overwhelmed at the psychological level. What we used to
Mm-hmm.
call back in the day, I went to an exam room and saw blanks and they forgot everything I had revised, or everything I thought I was going to write in that exam. So there are
Mm-hmm.
psychological reasons, in short, that
Yeah.
reason is psychological, why witnesses fail to persuade the court of law, even
Mm-hmm.
if they're actually telling the truth. The other reason is that some people attempt to be too clever. You know, they come there with bravado, with too much confidence, um, and through cross-examination, it is shown that these accounts they have much confidence in. I'll tell you one very short. We once did an election petition in which a witness comes to court and insists to the judge, this guy is called Kimadi. Now there is just another random guy in the courtroom, and he's one of those who had a laptop cooking up results in that constituency tallying center. And the
Mm-hmm.
guy is so fixated in his mind, this is the guy he saw. And remember, in his affidavit, he has written the name. So the judge just called the random guy, can you step
Yeah.
forward? Can you
Mm-hmm.
show me your ID? And it turns out it's a
He's
completely
not.
different. He doesn't even have that name. And yet this witness was swearing through his ancestors, through the Almighty God, through whoever, that this
Mm-hmm.
is the guy. I'm actually surprised he has the audacity to sit in this courtroom. So
Mm-hmm.
sometimes witnesses come to court with their own fixations, with their own illusions. Uh, and what I'm trying to say is that our character traits, the character trait of the person you've called as a witness, is he a man or woman who has too much confidence, even when he is mistaken, who is too fixated? He thinks
Mm-hmm.
he thinks the color of the car in question was blue. And it turns out it is not even exactly bluish. No,
Mm-hmm.
the women are much better than the men in colors. Then he said, no, it was
Mm-hmm.
beige. No, it was turquoise or whatever. And when
Mm-hmm.
the wreck is brought, it turns out the car is not exactly blue. Or he had his own thing. The car was actually red, but he saw his own things in his own mind. He's
Mm-hmm.
not lying. He's actually saying the whole truth and nothing, but he's mistaken.
Yeah. Yeah.
So I could go on and on, but all I'm saying is that there are several reasons, even those I've
Mm-hmm.
given up as examples, why witnesses who are otherwise telling the truth somehow don't achieve what they had hoped to achieve through the evidence. But I hope our followers can find a common denominator in all these examples I've given, is that the
Mm-hmm.
issues that could be addressed with good preparation before you take the witness
Okay.
to.
Okay. Thank you very much, Daktari. Now, you mentioned about witnesses coming to court to witness, thinking they are witnesses, but they are not really witnesses in the proper sense of the word, because what they are coming to witness is not what they actually witnessed in real sense. They are coming to tell the court what
Mm.
they were told or what they had.
Yes.
And just to pick it up from there, how does the rule of hearsay evidence operate? And are there exceptions?
Yes. 2 days ago, I was posting on social media
Yeah.
that about the hearsay rule. If we simply state the rule, it is to be found in section 48, section 6, section 33, section 63. I could say virtually 90% of all the sections in our Evidence Act are actually about ESC and its exceptions. The irony is that the word ESA itself does not appear anywhere in the statute or any subsidiary instrument made at the rate. Yet, if you know what ESA is, which I hope I can help to unpack, then you would realize that almost every section you find in our Evidence Act has something to do with ESA. And basically, the rule against ESA is a rule that says when you come claiming to be a witness, you must have actually witnessed the event in question, the act in question, the phenomenon in question. And for purposes of the law, for you to be a witness, the matter in respect of which you have come to give evidence in court must be a matter which, if it is capable of being perceived by the sense of sight, you saw it personally as it unfolded. You cannot come to say, if Lynn had seen it and now gave me a report. No.
Yeah.
And of course, if you must have seen it with your eyes, it means you must have been present at or near the scene of the event as it happened. If it is a matter that could be perceived with a sense of hearing, I heard him call the complainant Mboa. You must have actually have heard the accused person utter that word Mboa with your own ears. If it is Evelyn who heard it, and then Evelyn told you, that is hearsay. But a lot of people also forget that hearsay applies not just to oral evidence. It in fact applies to all other forms of evidence. I'll give you a good example. Somebody filled a P3 form at a hospital, and he was attended by a Dr. Dracula. For you to produce that P3 form in court, that is written evidence, it's documented. If you want to rely on the content of that form, which says that the victim had a huge laceration of 3 centimeters on the right cheek, it is the officer who filled that form under the rule again is easy, who can come and say, yes, I examined this patient, I measured the cut, it was 3 centimeters, and that is why I wrote in this. So I'm the one who filled this P3 form. If anyone else came to testify as to that P3 form, that P3 form will be inadmissible because it is written hearsay. To the extent that the person who authored it, that medical officer, that nurse, that surgeon, whoever they are, has not been called to produce it. The court cannot rely on that form to conclude that there was a cut on the right cheek and it was 3 centimeters wide. But yes, it can also apply to opinion. And there are very many things in the modern world where we have experts in this, experts in that, and whatnot and whatnot. And again, you have many people coming and saying, you know, the HIV virus is the one that causes AIDS. That's a technical point of medicine. And or somebody is saying this victim died of asphyxiation after strangling. That is an opinion as to the cause of death. Now, that opinion can only be given by the guy who performed the autopsy under the rule against TSA. So the evidence itself is evidence in the realm of an opinion. The pathologist or postmortem guy did not witness the strangulation. Not a witness to the strangulation. He was not present during the attack, but he's an expert who has a special knowledge in examining dead bodies using scientifically verifiable methods to arrive at an opinion as to the cause of death. This body was found floating in water, but his opinion is that the cause of death was not drowning. The person was actually killed elsewhere, and the body dumped in the pool so as to make it appear like he died of drowning. And let me tell you an interesting one. You know, these days you say men died in the line of duty. And, you know, we take some things, and unknown to you, it may well be that this guy was forced to take the Viagra tablets on gunpoint. And the attacker stayed until the act now conked out. Then they left the guy foaming in the mouth. Then you're there and you've just concluded that the cause of death was this guy overdosed with Viagra and whatnot. So what I'm saying is that there are many matters, there are many forms of evidence. We give oral evidence, we give written evidence by way of documents. Sometimes we give real evidence, which means we are bringing the knife itself that was allegedly recovered from the crimes. Sometimes we give opinion. Sometimes we give circumstantial evidence and whatnot. So there are all these species or different types of evidence, but for purposes of the rule of ESC, it must be direct evidence. That evidence should emanate from a witness.
Thank you. Thank you very much, Dr. Ari, for that. And other than the rule of hearsay evidence, what are the other proper procedures that a lawyer should adopt in producing documentary evidence, oral evidence, or digital evidence?
So for oral evidence, I think we are clear then the person must be a witness in the literal sense of the word. For documentary evidence, the rule is you must produce the primary evidence, which is the original copy of that document as it was made. And of course, there are technical rules, what is an original and what is not an original. But the point is, if it is documentary evidence, unless you are able to offer sufficient explanation why the original is not placed before the court for the court's inspection, even if you have a copy or a scan or whatever, which from the real world may be just as good as the original. Unfortunately, that's not how the law works. The copy, the photocopy, the scan is not really evidence. And yet, intuitively, the typical guy would say, yeah, we have this contract we signed, or this document he signed, this confession he made, or this police statement he made. Unless you have the original, there is no documentary evidence before the court. Of course, there are many exceptions, which I don't think constraints of time and whatever. There are even many exceptions to the ESAO constraints of time. Again, for electronic evidence, this is evidence in digital form. In the world we live in now, that evidence would be stored in a computer device. And by computer device, that includes mobile phones, includes tablets, includes the traditional computer, basically any digital medium on which data could be stored. And the rule for that class of evidence, for it to be accepted in court, is that you must give a document called a certificate of electronic evidence. And that would be a certificate prepared by the person who inputted the evidence into the electronic device, whether it's a flash drive, whether it's a mobile phone, whatever it is. The medium is really neither here nor there. But you need a certificate saying that I am Mr. So-and-so. I am the one who recorded this clip now being presented before the court, or I'm the one in charge of this CCTV system that allegedly recorded the robbery or whatever it was, or the accident. And this computer device, whatever its format, was in good working order at the time the recording or the data or information was put on it, and it was not laboring under any defect. And those defects would usually be viruses and bugs or various other forms that would have any bearing on the accuracy of the content. That content may be audiovisual, maybe text, maybe combinations of all that. And
Mhm.
most importantly, the recording was done by someone authorized to be operating the device in question or who had law of access to it. And lastly, that it has not been tampered with. Those are the safeguards
Mhm.
embodied in the law as enacted by Parliament for you
Mhm.
to rely on electronic evidence. Yet in the world we live in, a typical person would say, but there was live TV coverage and it was being
Mhm.
broadcast by Citizen, by
Yeah.
NTV, by whoever. Judge, what do you mean there is no evidence of this matter? We all
Mhm.
watched live this police officer shoot this
Mhm.
peaceful
Yeah.
demonstrator who was only
Mhm.
holding a bottle of water. And people don't know that, yes, that may well be, but it does not fall within the technical rules of evidence law, and therefore it is not admissible.
Mhm. And I'm just wondering, as you're speaking, Doc, how do we guard against deepfakes, especially with the technology of AI? Yeah, where someone uh, fakes something and poses it to be the reality when it's not.
Yes, unfortunately, it means that as we enter into the world of fake news and fake information and
Yeah.
disinformation and misinformation, the courts will even be more stringent then on those requirements as to the certificate of electronic evidence, because it is that
Mhm.
certificate that gives the court the comfort that we can rely on this document. And of course, if you give the certificate and it is
Mhm.
shown you are lying, then that's a contempt of court. Because a lot of people
Mhm.
don't know to produce evidence you know to be fake before a court of law is not just perjury alone, it's also a contempt of. But a lot of people think only of the perjury because it's the obvious offense. It's actually a
Yeah.
contempt to
Yeah.
produce before a court of law evidence you know or have reason to believe is not reliable.
Okay. And Doc, I'm also thinking of a scenario where your client confides in you that we have this evidence, but we stole it, yeah, from this government organization or this organization. What should you do as a lawyer when you have access to this very crucial piece of evidence that was accessed through an illegal means like stealing?
That brings the questions of the interplay between ethics and law, and as a
Mhm.
matter of evidence law, and as a matter of judicial practice. Our courts are traditionally, generally speaking, hostile to evidence collected through unlawful means, especially in situations where there
Mhm.
are lawful means of obtaining that evidence. Usually, this problem has arisen in the context of PFM type of disputes. There was this procurement list with this corruption or whatever. Someone says we received this whistleblower report and whatnot, and the judges have been asking. But we have a law called Freedom of Information Act
Yeah.
that has a framework through which you could have obtained this evidence. Why didn't you follow it? And the approach of the courts has been, sorry, we can't allow you to rely on that evidence because you cannot enforce the law while breaking it. So it's
Yeah.
a question of principle. In
Mhm.
the traditional sense, this problem took very different dimensions. It was usually about law enforcement officers intercepting your calls without a warrant from the court, intercepting your SMSs without a warrant from the courts, searching your house without a search warrant, and then recovering
Mhm.
items they claim implicate you in an offense. And in that tradition, or not before this modern problem of pervasiveness of technology and whatnot, the classical approach in the world now, let's say before 2000, the year 2000, 25 years ago, the classical approach was that it didn't matter how evidence is obtained as long as it was relevant.
Yeah.
And the only exemption were with regard to confessions and admissions in criminal cases. That
Mhm.
seems to be the rule still enacted in our Article 50 of our Constitution on fair trial. I think it is about Article 4, that evidence obtained in a manner that breaches the fundamental rights and freedoms set in the Constitution is not
Mhm.
admissible. If its admission would render the trial unfair or bring the administration of justice into disrepute. And traditionally speaking, even today,
Mhm.
courts have a different standard for criminal cases where it is law enforcement that seems to be violating privacy, to be conducting illegal arrests, illegal searches, and whatnot. Most likely such evidence will be thrown out. Never mind
Yeah. Mm.
that the rule, technically speaking, is that it is immaterial how evidence is obtained as long as it is relevant to the problem before the court.
Okay. Thanks for that clarification, Doc. We began by talking about the fear that Kenyans have in being witnesses before courts of law in criminal cases. And I'm just curious to hear from you. What are the forms of protection that our law accords to these witnesses, who volunteer to be witnesses in criminal cases?
Let's say there are general protections first, and there are also protections that apply to certain types of witnesses.
Mhm.
There are protections, for instance, for for children witnesses, for their protections for victims of, say, domestic violence, and other intimate partner type of violence. But there are
Mhm.
also protections that are given to witnesses based on the type of problem before the court. If, for instance, you're testifying against terrorists,
Mhm.
against drug dealers
Yeah.
involved
Mhm.
in other national, international trafficking. If you're testifying against illegal organized groups, and those
Mhm.
again could be local, could be national, could be multinational,
Mhm.
then, of course, the problems of potential retaliation, potential elimination become very real. So our country has a law called the Witness Protection Act. And under that act, the witnesses could be given various forms of protection. They could be put in a shelter where
Mhm.
they are now shielded from any physical harm and threats. They could be given new identities for purposes of, again, concealing their identity. If it comes to giving evidence, they can testify behind a blurred screen. I'm sure even
Mhm.
in this Zoom, if we want, we can blur the screens so that you
Yeah.
don't see my face clearly. Sometimes the voice can be distorted if they are testifying via electronic means,
Mhm.
and in short, there are very many. I'm just mentioning the obvious ones. Since
Yeah.
there's a general rather, the real problem is not whether there are witness protection mechanisms embodied in
Mhm.
law. The real issue is how they work in practice. You know, the Gen Z say mambo kwa ground, and different. So on
Mhm.
the ground, you'll find whether it is the law enforcement agencies or the witness protection agency itself. uh, we are a third world country with very many resource constraints, with very
Mhm.
many capacity constraints. And you may find the nice things written on that law about witness protection. On the ground, the agency actually doesn't have the, the capacity or the resources in terms of budgetary allocation and technology and whatnot to provide the level of protection that would be optimal to the risk that that the witness would face by coming to give evidence. And part of the reason people don't want to come to give evidence, especially in criminal cases,
Mhm.
many criminal offenses, most of them involve either an element of violence or an element of dealing with people who are inherently dangerous. I mean, that's why we send them, if
Yeah.
found guilty, to
Mhm.
prison for correction, for rehabilitation, and whatnot. So you're coming to testify about guys who pose real danger to you, to your immediate family, to your loved ones, and whatnot. So to me, then the question is, have we put enough budgetary resources? And if we have put them, have we invested in proper technical capacity, sufficient equipment, and all the multiple range of things required who have an effective witness protection program. In my experience, what we have is not effective. It is a far cry from what would be ideal. But then I always remember we are a poor third world country, and as long as that is our economic situation, then we can
Yeah.
only hope for so much perfection from our public agencies.
Mhm. And Doc, as you speak, I'm also thinking of the disabled, yeah, especially with the uptake of online courts. Now,
Yes,
I'm
yes.
imagining of, a disabled person, maybe say they're deaf, they are blind, they cannot see the screen, they cannot, I don't know, how does this play out when it comes to effectiveness of giving evidence in court?
Unfortunately, not very well in this country. For instance, I mean, during the election cycles, you hear IEBC telling you we have 44,000 polling stations, and
Mm,
even for an important exercise like that one, you're told these thousands of them don't have access to 3G network, they don't have access to 5G network or whatever G
yeah.
network. Uh, the internet itself is not free in Kenya. So you have immediate concerns like bundles, bandwidth, and
Mm-hmm.
whatnot. And the short answer to your question is that we have many challenges. There seems to be an assumption that virtual courts are more accessible than physical courts. And whereas that may hold from a purely textbook point of view, I mean, from a purely analytical desk work point of view, there are many conveniences and cost savings and accessibility advantages that come with a virtual court compared to a physical court. But on the ground,
Mm,
again, how many people in Kenya have access to state the internet that can stream a video conference? Very
mm,
few. How many people can afford it? How many people can afford it? But the place where they are, there is no, say,
mm,
3G network or 5G network. How many people have an appropriate device? This call, for instance, I'm making it through a huge, ultra modern computer. How many Kenyan citizens with our income per capita
mhm,
have access to such a computer like the one now I'm using to deliver this talk? And in short, there are many things we assume that may appear sensible from a purely textbook point of view, and they are not
mm,
always true just because they sound nice and true on paper.
mhm. Okay, thank you very much. Yeah, it's sometimes it's a sad situation we find ourselves in, and so, but the system ought to be more proactive in order to accommodate everyone, especially the disabled and the vulnerable. Now, when we talk of witnesses, we are assuming that this accused person perhaps has a legal representation, but there are also scenarios where legal accused persons do not have legal representation in court. And, you find that there is no guidance, completely no guidance on how the evidence should be adduced, the order, the procedure. To what extent should the judges and magistrates intervene without necessarily looking biased towards the unrepresented accused person?
They have a limited scope for accommodating, uh, if you like, a warning, advising such
Mhm,
unrepresented persons. I should have begun by saying that the vast majority of accused persons in Kenya are not represented by a lawyer.
yeah.
Those are the majority, actually. They are not the
Mhm,
exception,
yeah.
they are the norm. And that is, of course, a factor of the type of country we have said we are in. If you live on less than $1 a day, which is the reality of most of our people, uh, affording a lawyer will surely be something far away from your realities. Um, so what happens is, unfortunately, you have to confront the prosecutor who is himself a lawyer. And
Mm,
in our adversarial system, that can result in grave injustices. So the rule of thumb, what I usually advise people is, if you're you're charged with a serious crime. I know in practice they only treat treason, murder as the offenses that may warrant you being provided a lawyer at state expense. But in these days, you
Mm-hmm.
get people also charged with other fairly serious crimes that attract very hefty penalties. Under Sexual Offences Act, for instance, the
Mm-hmm.
penalty is out of this world. In my view, that's a case where the accused person should be provided a lawyer. These days, you're charged with what we are now calling economic sabotage crimes. Uh, you vandalized a transformer or whatever, or accused of tampering with a road or whatever. These are offenses that can attract very serious consequences if found guilty, even though the way they are framed, because of the nature of society, we don't seem to see them as serious until the sentence is announced. We are all socialized to say rape is very serious, murder is
Mm-hmm.
very serious,
Yeah.
treason is very. Wait until you're charged with, uh, computer abuse and misuse, whatever, just because of a WhatsApp chat
Yeah.
you
Yeah.
shared, and then you check the penalty. Oh, you mean this is more serious than cattle theft in terms of the penalty? Or you are just a peaceful demonstrator, there to see
Mm-hmm.
public order and whatnot and
Yeah.
whatnot.
Mm-hmm.
So for me, the point is perhaps civil society, perhaps the judiciary itself should be more conscious of the extreme inequalities that characterize our society and maybe make special accommodations uh, for for accused persons who are not represented by a lawyer. The the,
Mm-hmm.
the typical legal challenge is that our justice system is adversarial, built as it is on the British type of legal system. And
Yeah.
in an adversarial system, then there are limitations on how far backward the judge or magistrate can bend without being seen to be assisting one side. It's a question of law reform, and until we confront it, unfortunately, the dominant approach would be where the judge or magistrate will play unaware of the obvious inequality of arms.
Mm-hmm.
The theoretical presumption under which an adversarial system operates is one of equality of arms. That is to say, both
Mm-hmm.
sides have equal capacity to do research, equal capacity to engage lawyers, equal capacity to mobilize witnesses, equal capacity to undertake independent investigations and whatnot. And that presumption is, of course, although our students may sing it for purposes of passing their law exams, it is a presumption completely out of sync with the realities on the ground
Mm-hmm.
due to the type of society I said we are. And for me, what annoys me is to see judges, magistrates, and lawyers in the University of Nairobi. I describe them as memory verse speakers. They just recite these things we are taught in class, equality of arms, the system is adversarial. Yet they
Mm-hmm.
seem like you listen to him and does this guy live in Kenya? Does this judge live in Kenya? Does he know what it means to interact with a typical Kenyan police officer? Because he was trained under a curriculum that came from England.
Yeah.
And the typical behavior of the English police constable compared to the typical Kenyan police constable is like from
Yeah.
Earth to Pluto. Basically,
Mm-hmm.
there is nothing to compare. Yet you're relying on a legal template or a legal doctrine or a legal attitude whose superstructure is the British legal system.
Mm-hmm. Wow.
Let me give you one good example.
Mm-hmm.
I Just last year I went to a court in Kajiado. We were praying for bail, and it reached a point where it was clear even if we were granted bail, our client would not go through the bureaucracy of processing it. So they were going to spend the night and the weekend in police custody. The problem I had was some of them had small babies. And at that point, when we are taking plea, they still enjoy the presumption of innocence.
Yeah.
And before they were arraigned in court, the police had arraigned them, I had granted them a cash bill of 100,000. Now that we're in court, they were asking for millions. But the issue was not even the millions. The issue was we were still in court by 12:30 p.m. And I knew the banks will close at 3. So even if we are granted bail and we have the money, by the time we go to the bank and then come to the cash office, to war office, our clients will not, and it's a Friday. So I tell the magistrate, you can accommodate my guys. They were granted a police bail of 100,000. The police are still holding that money, and since from the time on the clock, clearly, even if you grant them bail, they will not be. Why don't you allow them to go home over the weekend, and we can process the bail on Monday? And
Yeah.
of course, I tell the magistrate the reason I make this request is, as you can see, these are young parents. They have young kids who will be completely traumatized, and these kids even have no caretaker who would be with them if their parents were to spend in custody. Then the prosecutor stands up and says, uh, "We've never had such a frivolous reason to accommodate. We arrest people every day, and they are not the only Kenyans with young, tender children." Of 2 years or whatever, that is complete nonsense. And I recall asking the magistrate, what happened to the whole idea we were taught back by Shakespeare that yes, we administer the law, but it has to be tempered with mercy and empathy and feeling. Surely we
Yeah.
are dealing with people who are not a flight risk. We have committed, will comply with. Why must they spend in custody over the weekend at this stage when we are just taking plea and you're already holding you yourself, the police officers agreed they could you could admit them to cash bail, which you're still holding. And you can hear in the whole conversation is no, we have rules, they are very clear, this is how they operate. The interplay between the rules and the humanity, we reached a point where I ask, is this prosecutor a human being? Is she a mother? It was a she, unfortunately. And eventually, the magistrate actually agreed with me and said, it's not like these guys are going to evaporate into thin air.
Yeah.
I will allow them to go home, but on Monday, you must comply. And if you don't comply now, I can bring the sledgehammer on you.
Mm. Beautiful. At least that is comforting. I know, Doc, we have talked about hearsay evidence, but allow me to take you back a little bit.
Yes.
It has just crossed my mind, when we talk of dying declarations, someone
Yes.
confiding in you, Dr. Mudomi is the one who shot at me and killed me.
Mhm.
How do we treat this kind of evidence when it comes to witnessing in court?
The answer is that there are countless exceptions to the ESA rule.
Mm,
And in fact, the bulk of our evidence act is rules that if you understand what ESA is, it's not difficult to see this rule is an
mm,
exception to hearsay. So then declarations are utterances made by someone at the point of death. And of course, we have an old proverb that says, the dead tell no tales. So
mm,
perhaps the deceased said, it is Mr. Mudomi who shot me. Then
mm,
that was the last utterance he said. And that is the only evidence. If, of course, Evelyn comes to say before Mudomi died, he had said it is Mr. X who shot him, Evelyn did not witness Mr. X shooting him. So what she is saying, she is reporting was that the deceased said, and the
mm,
deceased cannot be called from the grave to come and testify as to who shot him. So you find in that situation, the only evidence you have is the evidence of Evelyn, who had the deceased say who shot him. That
mm,
utterance by the deceased as to who shot or attacked him is what the law calls a dying declaration. A
mm,
statement made at the point of death. Um, at common law, they were admissible and they remain admissible today under Section 33 of our Evidence Act as one of the countless exceptions to the rule
mm,
against TSA. And the rationale for that exemption is that one, there is a presumption, which is a controversial one, that the point at the when people in those circumstances faced with the inevitable death, they have no reason to say it is so and so who attacked me unless it is true.
Mm-hmm.
The counter thinking is that even at the point of death, people might want to protect the real attacker perhaps because he's someone special to them and they don't want him to go to jail, even though they know now they are leaving the world
Yeah.
because of the attack. Sometimes
Mm-hmm.
some people may want to implicate those against whom they have held lifelong grudges. You know, there are people who never let
Yeah.
grudges go, even
Mm-hmm.
at the point of death.
Mm-hmm.
They still can't forget you snatched their boyfriend 50 years ago. So they were attacked by Mr. X, but they say it is you who attacked them. So that
Mm-hmm.
at last you're left, they can fix you one last time before their last breath. So there are controversies about the presumptive reliability of
Mm-hmm.
statements made by people at the point of death. Because even when people are at the point of death, there is research that shows they might actually have motivation for lying. So that's one
Mm-hmm.
of the controversies about dying declarations. But as a matter of formal technical law, such statements are admissible under Section 33A of our Evidence Act as an exemption to the rule against hearsay, and they are only admissible if they relate to the cause of death or the circumstances relating to the transaction that led to their death or to the identity of the
Mm-hmm.
attacker. It's still a very circumscribed window. If I may go through a list, there are many other exceptions to
Mm-hmm.
hearsay evidence, where the person who would be the witness, as I defined it earlier on, cannot be found or is dead or is alive but cannot be brought to court without a degree of expense or delay that would be
Mm-hmm.
unreasonable. We are not going to ship a witness all the way from Vanuatu, from Australia, New Zealand to come and testify to a transaction if there
Mm-hmm.
is alternative evidence. The
Mm-hmm.
cost of shipping such a witness and the inconvenience might be deemed too disproportionate to the concerns of adhering to the rule against hearsay. So that's another exemption.
Okay.
Uh, Hearsay evidence may be given of a matter of ancient customs and rights. For instance, under the Bukusu, what are the rights of a widow upon the death, or what are the rituals to be ancient customs by their very nature because they are settled over a very long
Mm-hmm.
period of time.
Mm-hmm.
It is assumed that one, it would be unreasonable for you to call the Wahenga who laid that custom 5 centuries ago. They are not going to be around anyway.
Yeah.
So you're not going to be then beyond to advancing a very useful argument to object to evidence of a custom, especially if it's an established custom that dates centuries and centuries. Anyone who is familiar with the custom can testify to it, notwithstanding they never saw the creation of the custom with their own eyes or with their own ears and
Mm-hmm.
whatnot. Hearsay
Mm-hmm.
evidence can be given of matters contained in public documents and public reports. By this, we mean statements filled by public officers in the course of their duty. If you go, say, to the civil registry at the Attorney General's
Mm-hmm.
office, there are many things they fill, say, in a marriage register, they maybe in a company register, and the
Yeah.
idea is that you cannot be asked to insist that the particular public officer who made this specific entry. It is enough
Mm-hmm.
if the officer is one who works in that department and regularly interacts with that register or the document in which entries of that nature. And you cannot be asked to say that I want this document to be produced by the exact officer who filled it, because to do that would cause a great inconvenience to the public service. And in the vast majority of cases, it will not even be possible to establish who. You can imagine all the transactions, say, on e-citizen, if
Yeah.
you were to insist the specific person who recognized it from the back end out of 1 million or 5 million transactions that that platform processes every day, you're not going to be able to be a credible person by insisting you want direct evidence in that type of situation. Hearsay evidence may be given or professional matters that are set out in a treatise. if we use the international law, if Hugo Grotius wrote and confirmed that there is a rule of customary international law, and it is set out in a book by, say, Ian Brownlee, you're not going to be able to insist that Ian Brownlee, unfortunately died 2, 3 years ago, that he must personally be fished from wherever he is and come, because it's basically a simple issue. Is there a rule of customary international law that perhaps gives universal jurisdiction on every state to arrest and punish terrorists, to arrest and punish pirates? Then you'll be told, oh yeah, Hugo Grotius wrote on this many years ago. Lauterpacht wrote on it. In more recent times, Ian Brownlee has written on it. And therefore, anyone familiar with that branch of the law can testify as to the existence of such a rule without you having to insist. And I could go on and on and on. The point is, there are countless exceptions to the rule against hearsay, and those countless exceptions form the bulk of the provisions of the Evidence Act.
Thank you very much, Doc. I would have loved us to continue. There are quite a number of questions I would have loved us to discuss, especially you just taking us through the procedure of how to adduce this evidence in court. But perhaps we can have another session. I see we have quite a number of questions in the chat box. So I would like to bring this conversation to an end. Then we turn to the question and answer section, where we try to weigh in the concerns that our audience have raised. So first and foremost, we have Magnus. Beautiful day to learn from the law. Very funny as well. Okay, that's not a
So
question,
they
but
know
they're
the law
happy.
is just a moniker I use in light touch, not something serious.
So the law himself is here. Then we have Sheila Bahati. It's yet another beautiful Monday to learn the law from the law. Dr. Mdomiti Ankolo and Dr. Sala. Not a question again. Michelle, hello, Doctories. How do you strategically use intermediary to ensure a child's evidence is taken seriously without the defense lawyer scaring them into silence? Yeah.
Yes.
How do you strategically use an intermediary to ensure that a child's evidence is taken seriously without the defense lawyer scaring them into silence? Then we
First of
have
all, this is not a
Chris.
practice. Okay, yes, go on.
Okay, maybe we can take three, then
Yes.
you respond. Yeah. Chris, the law spewing it like there is no tomorrow. Okay, that's not a question again. Shayla, the law teaching the law, how the law should be the law. Okay, Eric Kibogo, good to see our good dog, Senior Counsel Modomiti and Kolu, always a great pleasure. Michelle, in Kenya, the prosecution usually has the last word. How do you structure our defense evidence so that the final impression left on the magistrate is a reasonable doubt rather than just a denial? Then Samata Mohammed. Thank you, Daktari, for your insightful remarks on evidence in criminal cases. I would like to ask, how can an advocate properly prepare a witness for testimony without crossing into coaching? So maybe we can take those three.
Good. So let's begin with intermediaries. First of all, this is not a practice that has taken root in Kenya, even though it is very well established in the UK and other developed countries. So it is up to counsel to then plead with the court that the case is one in which the child should testify through an intermediary. There are, of course, evidential challenges that arise. How do you effectively cross-examine the intermediary? There are questions, at least at the philosophical level, which of course the evolution of children law has told us they are not defining questions. How does the accused confront his accuser, who is the child victim in this case, Luckily, that is no longer considered a serious objection, but it's still an important concern from at least a criminal justice point of view, because I hope our audience are aware the safeguards embodied in the criminal justice process are accused-centric. The rationale is always that because of the huge coercive power of the state, it is easy to send the wrong guy to prison. And the trade-off is we'd rather we have several guilty persons roaming the streets than have just one of them who is innocent condemned. But the point for me is that it is a difficult balance, and the lawyer has to make that judgment call uh, on whether you are likely to achieve the best outcome through an intermediary, or do you want the child perhaps to testify through a blood screen or to testify virtually or whatever. It is easy to be fixated with one of the multiple safeguards because an intermediary is just one of the many available safeguards. And if you ask me, it has less probative effect when it is the third party we are calling the intermediary, who will usually be an adult testifying. I would consider the other witness, especially vulnerable or child witness protection mechanisms, much more useful to get the child to tell the story in their own way and in their own words. You stand a better chance of having a greater impact on the judge that way. So speaking for myself, even though intermediaries are available on paper, I would never use them before I exhaust the alternative mechanisms. Uh, the prosecution, of course, has the last word because in our adversarial system, it is the prosecution who bears the risk of failure to prove the case. An accused person has no duty to prove anything before a court of law. At any rate, not any of the elements of the offense. An accused person not only has a duty to answer or to offer an explanation for things the prosecution has already proved. So the reason the prosecution usually has the last word in criminal cases is the same reason why the plaintiff has the last word in civil cases, which is that is the guy who would fail if the court were not persuaded that the thing alleged to have taken place actually took place. Sometimes when the case has been proven to a level where a responsible judge would convict in the absence of an explanation, then it is the business of the accused person to offer an explanation that creates a reasonable doubt. And the reasonable doubt is not necessarily a reasonable doubt as to whether the act or omission in question took place. The reasonable doubt may well be whether he had the right mens rea. I hope I'm not talking too technically, Evelyn. I'm afraid if we have
No, no, no,
people.
you're okay. You're okay.
Okay. You know, every criminal offense has an element called mens rea. And lawyers sometimes reason like pedestrians. They are so obsessed with disproving the actus reus, which is the act or omission that is charged. In most of my cases, I actually focus on the state of mind, whether it existed, because you don't look credible if your client, like now the case I told you we're doing of those women I told you I was seeking their bail, it's a corruption case, and I'm not going to help myself or the client or anyone very much if I'm contesting that there was a tender and then they participated or that they received money. I mean, the prosecution has all the paper trail to prove all that. In one of those cases, what I focused on is simply to say the only reason you have charged this one is you allege they are a brother to the other one. Actually, they are not brother and sister. In another count, I'm saying uh, all these things you say happened are true, but this court has no jurisdiction. So what are we doing here? Yes, we admit everything you say. But under this section of the law, the court has no jurisdiction. So creating a reasonable doubt, the point I'm trying to make here,
Mm-hmm.
Lynn, is not always about questioning whether the accused slashed him with a panga to death, or whether
Mm-hmm.
the accused fired the bullet that resulted in death, or whether the accused was the one driving the motor vehicle that led to the injuries or to the death, or whether, in the case I just described, my client participated in a tender and received public funds. The reasonable doubt, every offense has several elements, and all you need is to focus on just one element. Because if you create a reasonable doubt on any one of those elements, and that element could go to the accused real or to the menstruate.
Mm-hmm.
Mm.
Okay. There was another question on how do you prepare your client
Yes,
without
speaking for
necessarily
myself,
coaching.
how I prepare them is as follows. One, I invite them to the office. We have a meeting with them in which I take their statement, so to speak. What are you going to testify on? And what is its bearing on the case at hand? Because if you don't do that preparation, part of the reasons cases fail, I said earlier on, is the person you have brought as a witness is not a witness to the fact in issue. It is a dispute in contract between Evelyn and Modomi, and this person has come to testify how Evelyn has always been a bad girl since childhood. Is she testifying to the fact in issue? No. The issue is breach of contract. So if she had nothing to do, how is she a witness to anything? Someone has come to testify as to a succession matter. There is a question whether a certain child, a certain woman, it's usually women, I hope I'm not being sexist, should inherit the estate of a dead tycoon and whatnot. And instead of focusing on whether they were dependent, whether the deceased treated him as whatever, they have just come to testify how the official wife is such an evil and selfish person. Or they have to come to testify as to this woman was actually his wife. When you don't need to prove he was his wife, what you need to prove is that she was dependent on him. Or they have come to,
Mhm.
he was his child. They even look alike. They are like carbon copies of each other. And maybe all you need is to show he had anyway accepted this as one of his children, which under the Law of Succession Act doesn't require genetic parentage. So for me, the first thing I do is meet the witnesses in the office, hear their
Mm.
story, and
Yeah.
help them to sieve out the relevant from the irrelevant. Unfortunately, in my experience, sometimes what witnesses think is relevant is
Yeah.
completely irrelevant, but yet for them, they think it is important for purely sentimental or
Mm.
other completely incidental reasons.
Mm.
They have a family feud, they have just come to father in court.
Mm.
And that feud is not important to me at all to prove the fact in issue. Two, I prepare witnesses for the shocks of cross-examination because unfortunately in cross-examination there is a small window. They can be asked questions that are not necessarily directly relevant to the issue and the inquiry, but which goes to their credit. How much credit should the court attribute to them? Are they believable persons? Are they persons of integrity? There is
Mhm.
one time I took a witness to court in my earlier career and I had not done this. So I didn't know whether my witness had any cobwebs in their closet. So the very first question my adversary asked them is, were you arrested 30 years ago for printing and circulating fake currency notes? It was an election petition that has really nothing to do with. Um, and my witness never recovered from this because they never
Mm.
expected this little dirty secret. I've gone with a witness who is, say, a priest. who is expected to be celibate, not to be fathering children on the side. And unknown to me, they are these cobwebs in the closet. And the very first question they ask, the matter is just one of public land or breach of contract. It has really nothing to do with the sex life.
Yeah.
But because they ask more window where things can be asked that are not necessarily relevant in cross-examination,
Mm.
my guy is asked, weren't you accused of molesting boys and you claim to be a man of God? Isn't that why the Vatican called you there and you stayed for 3 years under rehabilitation before you were sent back to the parish? And then, so the first thing I do in preparing witnesses is to tell them, do you have any closets in your cupboard so that I know in advance, so that then
Mm.
we can, in the event they are raised, first of all, you're not flustered and thrown off completely off track
Mm.
in your train of thought. And number two, so that we're able to deal with the damage control if some damage control needs to be done, or so that we drop you all together because in many cases you have more than one witness to a fact, and
Yeah.
either have to choose
Mm.
between the one with several cobwebs in their closet and the one with few or none. Clearly, I don't
Mhm.
need a brain to know where the choice will be. So one of the things I do in preparing witnesses is to take them through the shocks and surprises of cross-examination. And I tell them, uh, you know, things could be pulled out from your past that even though irrelevant, I may not be able to successfully object. I usually tell my students, and sometimes some of these surprises are not even things to be embarrassed about.
Mm.
Um, I did a case in which a fairly well-known Kenyan citizen who is a woman belonging to high society was asked, "How old are you?" You know, you would wonder what has my age
Yeah.
got to do with this. I thought that was an annoying or insulting or embarrassing question, and then before I could even object, the woman asked the judge, "Do I have to answer that, my lord?" Then the judge mischievously smiles and tells her, "Yes, I'm afraid, Mheshimiwa, you have to answer." And then uh, it is given, and it turns out she was born in 1930, and yet we all thought she was much, much younger by more than 50 years. Um, and the poor woman is really very embarrassed that this little, she has invested in keeping this young look, done several rounds of plastic surgery and enhancements and whatnot. Then this sort of thing is asked. And if you have not managed them, that such, completely irrelevant shocks could come, then you have a witness who completely suffers now
Mm.
stage fright and disorientation. And I also emphasize with my witnesses that they have to look their best. They have to wear official wear if they can, because
Yeah.
going by the example I gave earlier on, me attempting to enter some building in this city in my jeans and t-shirts, then I'm
Mm.
being asked Kijana and none, and then I go to the same building, oh, and I'm a senior counsel, how are you? Very different. And unfortunately, we live in a world in which people
Mm.
are judged based on first impressions and how they look and how they are. So one of the things I emphasize with my witnesses is that where possible, unfortunately, it's not always possible, shave those shabby beards of yours and just look business and formal. Uh, those of them who like wearing their younger and smaller sisters' clothes, I tell them, no, you can't go wearing that very short skirt that reveals your thighs and that very tight top that reveals your front offices because the impression you may give the judge might be very different from the one
Yeah.
we will. And I swear I'm not making up this stuff, Evelyn. I've gone to court once where we are
Yeah. Yeah.
busy trying to ask witnesses questions, and then because she's wearing those clothes that there are all these controversies about my dress, my choice, we know the judge is a male judge is not recording. he is engaging in an exercise I call optical nourishment in my more jocular moments. Then you go check the record, all these important questions you are hoping the judge is taking down. The judge was not actually taking them down because he was engaging in optical nourishment. So grooming is one of the things
Mm.
I I put a lot of emphasis in when I prepare my witnesses. And then, of course, most important, the witnesses, I said, must understand the story they are coming to tell. Because what
Mm-hmm.
witnesses do is tell a story. Where
Okay.
does it fall as far as the issue
Mm.
before the court
Yes.
is, and how does it assist the court to resolve that issue? If it is not doing that, then they're not being useful to me. And there are
Mm-hmm.
many times we fight with my witnesses because I'm struggling to tell them this thing you're obsessed with, this guy, how he is bad, or how she is a prostitute, or how he is very evil, is actually not important at all. Yet to them, they think
Mm.
it is very
Mm.
important.
Very important.
Mm.
Okay, we continue with the questions. Shaila Bahati, is it possible for victims of sexual offenses to pursue justice years later, like it happened in the US? And what evidence can they rely on to support their case? Then we have Nelly Kamunde, my good friend. Thank you, Dr. Mudomi and Dr. Sala. Tell us how courts treat Google location can be used to show alibi if you have had such an experience. Then
I have not had any experience with the Google pin drops and whatnot, and how they play out in court, but that would be in the realm of electronic evidence.
yeah,
The police
mm,
usually use these things, by the way. Sometimes how they place the victim at the scene of crime is by using all these telecommunication satellites and masts and whatnot. There are things they call triangulation and other funny names. So just for the record, that evidence about location and alibi is evidence given in our courts every day. For me, the challenge for a practitioner would be, have you actually taken time to read that report, because the accused person will have been given that evidence in advance as they are entitled under the Constitution? And as the lawyer, have you taken the time to actually understand the basics of the technology involved? I'll give you an example. My good friend Ongwe was in the Senate the other day, where a witness was saying their phone could not access the internet, but they were also admitting they were on WhatsApp chatting and exchanging some things. And you know, if you're not keen, like Ongoya usually is, Ongoya asked her, wait a minute, you told us your phone is not internet enabled. Now you're talking
mm,
of WhatsApp chats. How are you able
yeah,
to engage in WhatsApp chats on a
mm,
phone that is not internet
mm,
enabled? So
mm,
the police says, you know how we knew he was not in Meru as he claims, he was in Kilimani, Nairobi, is because his phone, which has the main number this, uh, registered on a signal in a mast on Gong Road, and also was noted on these other masts at Adams, and we
mhm,
triangulated, and now we placed him at the higher center. That's why he was. Is council Has council bothered to cross-check, to even rely on even basics like ChatGPT to see whether that story is actually true and it is actually possible? Or they have taken it for granted that because the cops claim they have all these things, and you know, some of them they redact, they say we can't disclose our means of doing this. So for me, it's a question of lawyers willing to learn. These things did exist when most of us, including you and I, were in law school,
mm,
and it's always a lifelong lesson. And the lesson for me is lawyers should be able to have at least a basic understanding that enables them to critique. Because if you're not able to appreciate and critique and draw your own conclusions, your client might actually be placed on a scene of crime that they were not there. Or I did
Mm.
another case. A young girl is using her grandfather's mobile number to commit crimes. The grandfather is in a faraway rural area, and it took me, a few questions for the guys in NIS to tell me, although this number is registered in the 85-year-old man's name, we have done this and confirmed that this girl is the one who
Mm.
is actually having the handset. And sometimes they use even deceased people's lines
Mm.
to commit offenses. So for me, the problem I have with this Google location and whatnot is if you're not careful, it's very easy to
Yeah.
frame someone. And if the lawyer is lazy, they will just be framed and sent to the gulag.
Mm. Okay, maybe speak also to the question on sexual offenses.
Maybe you
Being
can repeat the
pursued.
question.
Is it possible for victims of sexual offenses to pursue justice years later, like it happened in the US? And what evidence can they rely on to support their case?
They can. The technical answer they can, but like I always say, when I used to teach evidence law, I used to tell my students St. Paul's letter where he says, for me, all things are permissible, but they are not
Yeah.
always beneficial. So the fact that the answer to a legal question is yes does not necessarily mean that is the best way to go about it. The challenge
Mm.
with sexual offenses in the old sexist world where women were the predominant victims, these days, unfortunately, just this afternoon, there are salacious things going on the internet about female lawyers who are preying on young male interns and pupils. I don't know
Mm.
whether you've seen them. Some of
Yeah, I've
them,
seen it. Mm.
we were socialized to think it is women and girls
Yeah.
who are victims, and we now live in a world where increasingly the women are the
Mm.
aggressors. But the point back to the question is, whereas the technical answer is yes, you can seek justice several years down the line, you're
Mm.
less likely to succeed if you follow that approach. Why? Uh, the forensic evidence will most likely have been lost. A victim of
Mm.
sexual offenses is advised
Yeah.
to immediately go to the police station, and the police should immediately take them to the hospital so that if there are body scratches, if there
Mm.
is semen samples to be obtained, if there is DNA fingerprint to be obtained from this or that, the evidence can be preserved for the trial.
Mm.
So the problem with sexual offenses is if you come, forget many years down the line, just a few days down the line,
Yeah.
uh, the forensic evidence will have been lost. So I think that's why then we can learn from the old sexist rule that the
Mm.
common law judges laid, which is that a victim of a sexual offense should raise hue and cry at the earliest possible moment when it will be. Of course, we now live in a world where that may not be very practicable. The abuser is, say, a father, the abuser is an auntie or a close family member, and because of social structure, this matter has been kept under the wraps and it has been ongoing. So it is not always possible,
Mm.
of course,
Yeah.
to always raise you and cry at the earliest time. Sometimes the power dynamic, especially in family settings where the abuser is a relative, the power dynamic may be that even if he wants or he or she wants to raise you and cry at the earliest opportunity, it is not just not practical because that uncle who is molesting the young girl is also the one paying her school fees. So there are many cases where there are good reasons, but the point from a trial advocacy point of view, from
Mm.
a courtroom lawyer point of view, is that the sooner you raise you and cry, the sooner you file the complaint, the sooner you try to pursue justice, the better. Don't take comfort in the technical
Mm.
answer that, you can come even many years and you've seen people convicted even after many years. But I
Yeah.
must tell you, as a practicing lawyer, it is a very steep mountain to climb to
Mm.
convict anyone of a sexual offense that allegedly happened several months ago, let alone several years ago.
Okay, we move to TM 123. The right to remain silent in criminal cases means that the accused is not mandated to give any evidence. How does that affect the sentencing and trial of an accused if they decide to take that path? Then we have Michelle K6R. Hello, Dactaris. If your if our own witness suddenly turns against us in the stand, what is the fastest legal way to have them declared a hostile witness so that you can start cross-examining your own person? Then we have James Levi. What if someone frauds me? How many years do I have to report the matter?
Okay. Now, the issue of remaining silent is again where the technical answer and lived realities are very different. Under our constitution and our laws, an accused person is entitled to remain silent and to refuse to give evidence. Under the same constitution and law, the court is not allowed to make any adverse inference from the accused person for exercising that right.
Yeah.
That is where the technical law ends. If you read even textbooks, they tell you, however, the lived experience is that it will be very naive to assume no such inference is usually made. And that's why, again, now I want lawyers and law students and law practitioners. Just because the law gives you a certain right doesn't mean proceeding that way is the wisest thing to do. The typical judge is a human being. The
Yeah.
typical magistrate is a human being. Once
Mm.
evidence is adduced, somehow implicating you in the alleged offense, even if that evidence is not sufficient to secure a
Mm.
conviction, and you choose your right to remain silent, although they have a PhD in law like you, Evelyn, and me, chances are that the human being in them will conclude the reason you don't want to give evidence is because you have something to hide, and you know if you're cross-examined, then what you're trying to hide will come out. Same applies to one of the options they are given, which is to give an unsworn statement. And the law, it's a perfectly legitimate
Mm.
and legal way of the accused person giving his evidence. He is told if you give an unsworn statement, you cannot be cross-examined. The weight attached to such a statement is obviously very little, even though, again, the law gives the accused person the right to
Mm.
take that option. So my advice to practitioners has always been, if the court has ruled that your client who is the accused has a case to answer, it is advisable if they are exonerating evidence they could give, let them give evidence as opposed to saying, I exercise my right to remain silent. The only place people are entitled to remain silent and I don't know why they don't invoke that right is before the police officers at the investigating stage of a there is this assumption in believe that if the police or DCA or whoever summon you to record their statement, you are
Mm.
obliged to tell them anything. And I never even know why they issue those P52s and other forms because you actually have a right to go there and refuse to say. To me, that is the forum where that right should be exercised. If the police are going to catch me, let them not catch me
Mhm.
because the information I gave them somehow enabled them to connect the dots and see my role in the offense. But many people
Mhm.
assume if a police officer summons you to the station to record a statement, there is even no such thing in our law as recording the statement with the police. It's just something the police have created, and we have taken it as given
Mm.
that it is provided in law, and it is you have a
Mm.
right to refuse to answer those questions with the police officer and tell them I invoke my right to remain silent. In a court
Silent.
of law, an accused person, the question of remaining silent or testifying will only arise if the court under Section 210 rules, they have a case to answer. Until that such a decision is made, the question of whether the accused should remain silent or give evidence does not arise. And my advice is, if the magistrate rules you have a case to answer, even though the technical law is that does not mean they will convict in the absence of an explanation from you, you had better give that damn explanation if you have it, as opposed to choosing to remain silent. Hostile witnesses are
Yeah.
witnesses who promise you they will testify as to a fact in issue in a particular way, and when they come to court, they change and want to testify to a completely different version than the one they had told you they are coming to testify. And the law, the technical law, the solution is you can apply to the judge or magistrate to declare that witness hostile, which would enable you to cross-examine them and treat them as if they are witnesses for the adversary. Again, this is an area where the black letter law and the reality is done alike. I think I can make this point, Evelyn, because now it is
Yeah.
mentioned many times in my presentation. There are too many things in our evidence rules which don't align with lived reality, where the technical law doesn't align with good advocacy strategy. And it is foolhardy of any properly trained lawyer to take much comfort in the technical legal answers. I've already told you remaining silent is a technical right,
Yeah.
even embodied in the supreme law of the land. Yet the lived reality is that taking that route is foolhardy. Same for hostile witnesses. I usually advise people, why don't you do your background check so that you have witnesses who don't turn hostile or whose risk of turning hostile is so low? Because the technical law actually is that a judge is not obliged to grant your request to treat your own witness as hostile. In fact, under case law and the lived practice, judges and magistrates rarely ever allow you that request, which means if you've not done your preparation before you go to court to find whether your witness is a man whose story changes based on the inducement they are given, you're going to be stuck with the hostile witnesses and the hostile answers they will give. They will just come and, I was about to use the F word, screw up your case. So the rule of thumb I give lawyers, my law students, is choose ye your witnesses wisely, because you have time to prepare for trial. Don't pick men and women whose accounts changes like the English weather. So that if you find yourself in the unfortunate situation where you have to seek to declare your own witness as hostile, then it is because there truly were no alternative witnesses and there truly was no other way out. Because your application in any event is unlikely to be granted. Can I report or follow up a fraud after a long period? In criminal cases, the answer is yes, because criminal cases, generally speaking, have no limitation period. So a crime can be followed up even after the lapse of very many years. Of course, fraud as a civil matter is a tort, so the limitation period is 3 years. But for criminal cases which are our concern, there is no limitation. But again, that answer, although it is legally correct, it is not very useful. Because in practice, the more time that passes between the event in question and the lodging of the complaint and the beginning of the trial, the more difficult it will be for you to achieve a favorable outcome from the court. Because witnesses' memories will have lapsed, witnesses will have died, witnesses will have relocated or migrated from one place to another, documents will have been lost. There's so many things that happen as time lapses. So the rule of thumb is, again, there is a lot you can learn from the civil law maxim in equity that says equity is the vigilant. not the
Not
indolent.
the indolent.
The more time you take. So again, you see the technical answer is yes, you can follow it, even if it's after 50 years. But what are your chances of succeeding after the lapse of even a few years? Not to mention very many years. And of course, the
Okay.
more you also come, even when you have the evidence, I think I should mention this, Dr.
Mm.
Even if you have the evidence, the fact that you're coming up with this evidence after the great lapse of years or months or whatever is going to have an impact on persuasion. The more likely the judge will in their mind be saying, why is she raising it now? Why has she been
Yeah.
sitting on this
Mm.
complaint? Uh, is it because she sent him hi and he refused to answer? Now she has suddenly
Mm.
decided. So your motives are brought to question. And if your motives are
Mm.
brought to question, uh, I will tell you a case we did where my client was charged with some corruption offense that had happened
Mm.
6 years before, and they were called from retirement to come and answer these charges. And one of the questions we were asking is the motives. These officers allegedly engaged in these things. They remained in your employment for 3, 4 years after these events occurred. You allowed them to retire in peace. Now you're going to call them from retirement to tell them you committed a law, and even the law now had been changed. We're working with a new statute.
Mm.
Unfortunately, the legal system permits you to be charged under the old statute, even though it has changed. But you can see that we already have raising legitimate questions
Mm.
as to the motives. Githunguri versus Republic. You promised Parliament that these offenses will not be pursued. The Attorney General made public statements that they will not be pursued. Why is it that after the great lapse of many years, now you have come with a charge sheet asking Mr. Githunguri, and we all know what happened? Madame
Mm.
told him, go pray, physics, which mountain, these days mountains are political things. And basically the prosecution was stopped on its heels. Not because there was no evidence. There was actually evidence that the offense had been committed. The only reason the orders issued stopping the prosecution is the lapse of time. And because the lapse of time and on the facts of that case, it was clear the change of
Mm.
mind was driven by the political calculus of the day.
Mm. Oh, thank you very much, Doc. I know there are quite a number of questions we will not tackle, but in 1 minute, maybe we take this one because I think it seems to be lucky. Just in 1 minute, maybe make a comment on character evidence and its value in criminal cases.
The technical law is that the prosecution is not allowed to lead evidence showing or tending to show that the accused person is a man of bad character and therefore likely to have committed the offense in question. Of course, that's the general rule. There are many exceptions to that. And because the training of lawyers, both here and throughout the Commonwealth, is to be suspicious of that type of evidence, my usual disposition is to raise an objection if it is attempts are made to introduce such evidence. And luckily, there is one area where that evidence will not be introduced unless the accused and his lawyer make certain mistakes. One of the mistakes is to cast aspersions as to the character of prosecution witnesses. You know, there are all these people, I tell my students, who think a trial is about attacking the other side without good cause. No, a trial is about the facts in issue. It's not about the side issues of whether I like Evelyn or I
Mm.
don't like her or whatever other ways we have crossed paths in the past. No. The other mistake you could make and make that evidence admissible is the accused person himself taking the posture of a saint by testifying as to his own good character. So basically, with the exception of what we call similar fact evidence, there is no other situation where the prosecution will be able to adduce character evidence ab initio. The accused would have to be the one who has made one of the mistakes in section 55 to 57 that now renders that evidence relevant and admissible, which means the lawyer then should know the rules we discussed all those rules, McKinney and Attorney General for New South Wales. This is not really an appropriate forum to go into the nitty-gritty of it, but students trained, especially at the University of Nairobi School of Law, should not be making those mistakes. And if I usually tell them, if they do them, if they make those mistakes in their practice, they should never introduce me as their former lecturer, because I would disown the Kipete Rubies.
Okay, thank you very much, Daktari. It has been such a great pleasure listening to the law himself and just oozing out, quite a lot of knowledge, wisdom, all gathered in the years of practice. So thank you very much, Senior Counsel and Dr. Mdomi Piankolo. We really appreciate your coming on this particular conversation and the guidance that you have given to all of us. And I'm really sorry to the audience. I know there were quite a number of questions in the chat box, which we have not attended to. But please be encouraged to attend the next session and pose your question a bit more earlier so that we can attend to it. So please, to all of you, it's a big thank you. I really wish you the very best. Dr. I don't know if you have any concluding remarks before we
Just to
call
say,
it.
let the lawyers on the platform understand the law, and all the other things shall be added unto them. And lastly, I'd request from many people in prison for a recording of this thing. So if you're able to share the link to the recording, assuming there was one, I would also be happy to share with them.
Yeah, the link is the same YouTube channel that came with the poster. So when you click on it, it will bring you to the discussions. So please feel free. And for those who are attending, subscribe and comment, and let us continue engaging in these conversations. Thank you very much. Good night and God bless you.
Awesome.